Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm from the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and bitch get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. Late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
I'm having my Korean panic attack.
Hey, good morning, good afternoon, good evening, good night, everybody, whoever you are, wherever you are, whatever you're doing. I am so sorry that we got underway so late. Life happened. Life happened today. Wow. I apologize. Things that are normally within my control were suddenly not within my control. Not even worth getting into it. I take full responsibility. Although it was out of my hands. It was just never mind. Apologies. I hope you can graciously accept my humblest and deepest apologies for making you all wait. I claim innocence, but then again, buck stops here, man. Buck stops here. I could go the Sarah Boone route and say I didn't do it intentionally, but you know what? George is still dead and I'm still late. So, yeah. Wow. I'm so not ready, but you know what? We got to go with it. I didn't have time to comb and make the stash look presentable. I literally just ran in the door with 2 minutes to spare. And then because of life, and then there was outside life, and then there was inside life, and they both conspired, but we're here. Right. Terry M says Sarah's attorney can't practice. LNP attorney Stark can't practice. Why can't they practice? Their license. Her lawyer's licensed in Florida. There's no reason he can't. He's actually a very well known Florida lawyer. Paging Dr. Freud. He's a very well known Florida lawyer. So anyway, I don't know what that's all about, but he's perfectly able to practice there.
And by the way, if any of you have seen the hearing that we're going to be watching today, we're going to be watching the hearing that took place. Was it 2 days yesterday? 2 days ago. Do not spoil it for anybody. I've seen a lot of it. I've seen a lot of it. They didn't pay bar fees. You just pay the bar fees. You just pay the bar fees, and you're back in. No big deal. It's not a thing. Anyway, we're here. Let's deal with this, shall we? Right. We're going to be watching the hearing from 2 days ago. We'll see how it goes. Like I said, I've watched most of it, not all of it, but we're going to be here for a while. It seems to be a lengthy hearing. I don't have a like and subscribe poll up yet. Frankly, I don't deserve your likes right now, but I swear to God, I'll earn them. And but one thing I should say, we currently have a bunch of people here. We have 286 people here and 124 likes. A little over half of you haven't done your jobs. Okay, but like I said, I haven't given anything to like yet. But let's presume, for the sake of argument, or in arguendo, as lawyers are wont to say, let's assume in arguendo that I do something that you would find amusing and likable, or that you just happen to like the trial. Just hit the like button now while we're talking about it. And the same for the subscribe button. Hit that subscribe button. Let's keep going northward. We are 360 subscribers away from 81,000. Let's get to 81,000 before the end of this trial. That is my goal. So let's do that. Hit the like and subscribe buttons. If you have not hit the subscribe, please do. Sorry. And if you have already hit the subscribe button, just double check to make sure you still are. And if you've been unsubscribed by YouTube for some reason, just please hit that subscribe button again. And let's see. We'll put up the like and subscribe poll once we get underway, and I've had time to think of something to actually put up. Test Andrew Valentine, we see you. All righty then, because I don't have anything prepared, and there are no super chats or anything like that to read straight out of the gate. I will just make the announcement that currently we are sitting on the day 27 streak. We are on emotional support potato pig dog cam 27 days straight. We've unleashed the emotional support potato pig dog cams right up there, day 27 of the emotional support potato pig dog cams. Will we make day 28? That's up to you. If you want to make that happen, of course, we unlock the achievement. We've got super chats, PayPal, Cash App, Venmo, Zelle. We've got it all. Links are down there. The mods put them up there. That's completely for you to decide. It's not required, not begged for. It's just all in your hands. But anything anyone gives is always graciously and gratefully and humbly accepted, and we have fun with it. So decide what you want to do and go for it. But what the super chats do and things that guarantees I will see and read and acknowledge and respond to your comment. And if you are on replay, you can always do a super thanks. It's like a super chat, but you don't have to be here to do it. Right, that's it. We got that out of the way. Got the grift out of the way. Got the like and subscribe poll coming up. Let's bring up the window here. As you can tell, I'm still running on an adrenaline high. Now more than ever, I have needed the official drink of the Sarah Boone trial. Vodka and Tang. Why Tang? Because it's the Boone trial and we have Tang. Therefore, we have the Boone Tang suitcase cocktail. And it's Friday night, so there's a little extra vodka in there. Maybe somebody at the end of the show remind me to tell you everything that went wrong in the last hour. We'll do that at the end of the show in case anyone happens to really be interested. Right. Day 27 of Doggo Cam is right there, and we're going to bring up the trial right now, and then I'm going to take a big, deep breath and just relax for a minute, if that's okay with everybody. Super. I don't like that position. Let's go here. There we go. But that's why I did this one, because it covers the Law and Crime logo. I remember now. I do like this position. Oh, and while I was ranting and raving like a madman, we got Chris Rowland to the 99-cent super sticker with the $1 super sticker. It's a $, eyes on a happy smiley face. Thank you very much. Pastor Flash. What up, Pastor Flash? Goat flower. Goat. It's like goat. It's between a K and it's like a double hard K. It's like the sound doesn't exist in English. That's the problem. It's like if you somewhere it's halfway between a K and a G, and it's pronounced with like a glottal stop. So it's not a G, it's not a K, it's a K. So it's like got. Got. Got is flour in Korean. Thank you. That's your Korean lesson for the day. Got is flour. Stephanie, thank you so much for the $5 super sticker, which appears to be a hippo with wheels. His legs are spinning so fast. That's me. I'm a hippo, and my legs were running so fast they almost look like wheels. All right, that puts us exactly 90 away from day 27 of the Emotional Support Potato Pig Dog Cam. But again, this is not a grift for that. It's just a reminder. Let's get into it. Let me turn on the Hoojama What's It, the closed captions. We'll do normal speed because it's Friday night. I ain't got nothing to do. I got nowhere to go. No pressing social engagements. You are my pressing social engagement. So we can hang out. We can hang out at regular speed. If it becomes too tedious at some point for some reason, we'll bump up the speed. But until then, normal. Let's go. And of course, no volume. Oh, here comes Officer McMuscly. Sarah's around here somewhere. Oh, there we are. And while we're waiting for this, Island of the $5 says the audio is going to suck. That's how we know it's a real court hearing. Jeff's going to do his best. Have a Boone tang and roll with it. Happy Friday. Right. That's one of the things we got to roll with. Ordinarily, we would be doing this Friday evening PM because I like to go out and have a decent Friday night with friends and whatnot. But I forgot it was Friday because there's been 3 holidays in the last couple of weeks here. There's 2 holidays this week, and there's a holiday next Wednesday, and I just forgot it was Friday. So I said, hey, I'll be here at 9 a.m. Eastern, forgetting that it was a Friday. So I'm here. That you are my priority. I'll just go out and have extra fun tomorrow. Thank you so much, Island, for the warning on the audio. The parts I heard didn't sound too bad. We'll see. I never forgot my friends. They're just delayed. All right, come on, people. Say something. Say something. I'm assuming the audio sucks at the beginning because I didn't see the beginning. Oh, wait, I did see a little bit where the guys are like talking way off the microphone, which I'm assuming is going to be happening here. All right, come on. La 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 la. All right. I just assumed they were going to start talking because people are there. And again, apologies. I didn't have time to queue it up because reasons. Is my
press
okay,
defendants
working? Wow. All right. So it might not be so long after all. It was 2 hours and 30 minutes. Now it's only 2 hours. The dogs are already snoring, by the way, because it was cleaning lady day, and I take them to the office on cleaning lady day, and they didn't get any sleep at the office, so they're plumb tuckered out, and they're already sleeping. So any snoring you hear, any heavy breathing is not me. It is the 2 emotional support potato pig dogs that are all nestled snug and cute in their individual beds, awaiting to be released upon you people. Judge Kranick on the stand.
I'm ready when you are.
Audio only in the left ear. We'll speed it up if we need to, Aaron. We'll see how it goes.
William J. for the state.
James Owens for Sarah Boone.
Owens. Okay.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record form.
The judge's microphone is working. No question there. Also working is Sonny or Chris, gifting 10 Legal Vices membership straight out of the gate. Sonny or Chris, you have repeatedly been the man. Thank you so much for that. That's a great way to start. You get a foghorn for that. And if you happen to be Iron Rabbit, Lego Lisa, petrified. Oh, and Lego Lisa. By the way, next Wednesday is also a holiday here in Korea. So Wednesday morning is Tuesday evening U.S. time. So Tuesday evening, Ozzy Overlord and I will probably be doing part 3 of our Lego build. So check that out. Iron Rabbit, Lego Lisa, petrified, Sophie Schenk, Angel Baby 4210. Oh, my screen just rolled up. Yusra Kayab, Ali Cat, Ali Cat, I get it. Haha. Coyote Bait, Stephen H, and Meat Popsicle. Hey, Meat Popsicle, what's up? I haven't seen you around a bit, have I? You all got Legal Vices gifted memberships from Sonny or Chris. Give them a super special thanks. And with that, back to our overmodulated judge microphone.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress.
Wow, it's Sarah's birthday next Wednesday on the 10th. Happy birthday, Sarah Boone.
Suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024.
All right, that's why I told you yesterday to pay attention closely to the statements she gave during her police interrogation, because they want them suppressed for a reason.
The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based on what's
Okay. Wait a minute. We have to finish the sentence here. You might say something else.
valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Okay, that's an interesting comment there, because this whole thing they're focusing on is this motion to suppress the statement she gave the police, arguably based on because they left out one line of the Miranda warning card, which they're going to discuss ad nauseum here. But the judge is saying, okay, so you filed your second amended motion. Is this really something you really want to go forward and argue? The judge is showing a little bit of his hand there, I think, by saying, are you sure you want to still argue this? And he's like, yep. So not a good start for the defense.
Okay, so the sufficiency of the Miranda waiver is still at play.
Mm-hmm.
Okay, all right, thank you, sir.
Cool dude.
With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian, and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state.
Yeah, they already decided the leg shackle issue. Why are we going back with that? Okay, that'll be interesting to see, because they already decided, and she already agreed that at trial she would have no handcuffs, she would have no leg restraints, but she would be fitted with a ankle shock bracelet. I don't know why we need to discuss that. All righty.
Its request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Something else? Miranda card?
Yeah, if you look in the very back.
Hey guys, you got microphones. Use them.
You look in the very back. Okay. You see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records? Yes. I also have reviewed the 2 hour and 6 minute investigation that's pertinent to the motion.
And that's the one we watched yesterday. They reviewed what we watched yesterday.
Suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification as a DVD, courtesy copy, body worn camera.
Come on, dude. You got a microphone at the lectern. You have a microphone on your desk. Don't get chummy with the judge and lean up against the clerk's desk. We can't hear a damn thing you're saying.
I have reviewed
Thank
all
you,
of those
Judge.
in advance of today's hearing. Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1.
All right, while they're doing that, we have put up the like and subscribe poll for today, which is just a way to remind you to hit the like and subscribe button. It's not really that important in the grand scheme of the universe, but we do have our choices up there. So hit the like button, hit the subscribe button, and double check to make sure you're still subscribed if you've already done that, and then take our like and subscribe poll. Today's choices: how should Sarah be restrained during trial? Cuffs and leg irons, only leg irons, shock bracelet is acceptable, or zipped in a suitcase. Those are your choices for how Sarah Boone should be restrained during trial. Mark them off as you will. Right. This, I believe, is the officer we saw on the video. Who should have a 2-year-old child by now.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle. Chelsey. Last name is Koe.
Just tip that mic a little bit
Thank you.
towards your
Counselor
face.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I
How long have you been
It's a homicide detective.
over 6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I'm going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and
Again, real quickly here, the defense has made a motion based on her improper reading of the Miranda warning card, and they're seeking to just have her entire interview thrown out. And so they've made the motion. This is the state. This is the prosecution that is calling her as a witness to rebut the motion. It's their first witness against the motion being made by the defense. So this is the prosecution doing the these questions, and then after he finishes, the defense attorney is going to get his crack at her to ask her questions about the situation. And the audio does get better.
And do you go to the scene first, or do you do anything else?
For this particular incident, I got my partner, Detective Scott Lowen, and we headed out to the scene.
All right. And when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right. And did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone, or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also?
She is a little lip smacky with her answers when she starts, but we can get used to it. It's not Canton level, but it's there.
Similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Miss Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband.
Yeah, Brian Boone, the ex-husband, was on scene, and he basically said, yeah, they've got problems. they've got problems. She wanted me to come in. I walked through the door. I looked, I saw a pair of legs and said, I don't want to have anything to do with that. So I came back outside. But somebody you want to have something to do with is Adair K, because Adair K has gifted 5 Legal Vices memberships. If you happen to be Bethany W, Zizix, great little place in San Bernardino. We love Berdue, Zizix Berdue in representing special KL, Bama Girl of 1955, and Philip Kraft. You got a Legal Vices gifted membership from Adair K. Make sure you give her a super special thanks. And Voodoo Berries, Casey Anthony back on the stand in Florida here. Shame on you. This is a respectable police officer. Voodoo Berries, shame on you. What did the cleaning lady think of the Nicolas Cage blanket? That's an if you know people. She is a professional. It was folded up neatly and placed at the foot of the bed. Not a word about it. And Nicola Maxwell says she's got an attitude on her. Makes her not so pretty. The audio gets less choppy soon. I do not blame her for having an attitude. The defense just made a motion dragging her ass into court where they're going to try to eviscerate her and potentially get all of the evidence that she obtained during the interrogation thrown out because they're alleging she did a bad job. I would come in with a mighty chip on my shoulder too, so I cannot fault her in the least for that. I think she looks more like H3H3's wife than Casey Anthony. Gila, is that her name? Anyway, let's go.
And then I believe we then sat there and into our unmarked vehicle and had a conversation with her.
Is that conversation in the unmarked vehicle recorded?
Gosh dang it! I apologize again. I do not want to get behind on the on these memberships because this is super important. We are on a quest to banish the gray from chat. We want everybody to be green and colorful. So it's ban the gray from the chat. Make everybody a member, and that's what we're doing because Cherry Reed has just dropped a 5 Legal Vices membership, and it was dropped upon, where did it go? Where'd it go? Where are you, Cherry? Rested Pandy, Jason Lazzotti, Stephanie Mowry, Tony G, and Amanda Dennis. You got the gifted memberships from Cherry Reed. Give Cherry Reed a super special thanks if you got one. And also, of course, right out of the gate, again, keep it coming, ladies and germs, because this day, what the heck? This day 27 of the official Legal Vices. There it is. It's up there. I keep expecting somehow my arm to extend above where the camera is showing. The day 27 of the emotional support potato pig dog cam has just been extended to day 28. We hit the goal 28 days in a row, chat. And it is now officially that time of day where we introduce our co-host and we get to that important part where we announce that it is once again on for the 28th day in a row time to release the hose. And tonight, starting us off with our emotional support potato pig dog cam, it is Strawberry. Yeah, we're not going to do this layout anymore. We got to go back to this layout for the time being. That is Strawberry, one of the 2 emotional support potato pig dogs. Yoda, the other one, is over there. What's up, Yoda? We'll check on Strawberry here for a bit. All right. Thank you again for getting us to our goal 28 days in a row. Don't let this stop you, though. There are more achievements to be unlocked as you see fit. All right. Thank you so much, everybody. I don't want to get, oh, my Lord in heaven. IT Goatee Brad has just dropped 5 memberships. Holy crap. We're not even going to be able to get to this because we're going to be suffering from the generosity of people. A bidding war has started. A gifting war. IT Goatee gave gifted memberships to Paranoia 07, Tiffany, Kim, Ryan, and Cha-Cha. If you happen to be one of those, many of whom only have one name, make sure you give IT Goatee a super special thanks. And Tammy, woo woo, yeah, all the pretty colors, ban the gray. I completely agree. We got 512 people here, many of whom are gray. We need to fix that problem. But we really also need to fix the problem of not pushing play and talking too damn much. Let's go. I said, let's go.
Recorded?
There we go.
Yes, audio recording.
And can you describe this unmarked vehicle for the court?
At the time I was in a unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Scott Lone sat in the
She really reminds me of
Did you have any
the
conversation
secretary
with her
on
about
Brooklyn
the facts of the
Nine-Nine.
case or your investigation that wasn't recorded inside the car?
With the
And
vocal
that was
fry
all
in it, too.
recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive? At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
It's always touch
Right.
someone before you touch
And
it.
ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Not go back in her house. But yeah,
Prior to that, had she been detained and requested not to leave the scene?
one more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Which as we saw that on the video, because what they've done is they had the body cam footage that we watched 2 days ago. Then there was a separate interview that took place, I guess, in her car, and then the next day there was the interrogation at the police station. And what they're asking is, with the body cam thing, was she told she wasn't supposed to leave? In fact, she was told the opposite. She said, you can go wherever you want, do whatever you want. And Sarah even said, run, which surprised me that they didn't go, oh, on second thought, never mind, you're coming with us. Because Sarah actually suggested she might run. So, yeah, definitely was not told you can't leave anywhere.
February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes. It had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's part of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through?
Yes.
As opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card?
Yeah, the public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation.
Well, see, and this is a problem for Sarah. They can't do the standard traditional. You had tunnel vision. You didn't look at any other suspects. When your client says, I am the only person there at the time that he died, that kind of narrows down the field of suspects. So, that's kind of a negative for the defense there.
But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
Again, real quickly, I'm downloading the orders. The judge has handed down his ruling on these motions that we're reading today. So I'm downloading them right now, and we will get to them at the end of this hearing.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it
And that
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right. Do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her?
Okay, real quick here. Also, while I was downloading that, people were saying that he is not eligible to practice law. You might be looking at a different James because he is. I'm looking at his bio right now. He says eligible to practice law in Florida. He is fully able to practice law, and I would have been surprised if he wouldn't have paid his bar dues. So I'm not sure which James Owens, because there seems to be 4 James Owens that are licensed with the Florida bar. So I'm not sure which of them you were looking at, but he is currently eligible to practice law. Two of the 4 are not. So looked at the Florida bar website, him in Milton. Yep, James Sylvan Owens is eligible to practice law in Florida on the bar side I've got. So, yeah. Member in good standing, eligible to practice law. No disciplinary history. So that's what I've got from the Florida bar side. Yeah. I don't know. Because Florida has blocked access from outside of the US. So I would have to kick on my VPN, and that would screw up my stream on my computer. But so I've got it on my phone here. I don't know, probably can't see it. Yeah, that doesn't help at all, does it? Oh, yeah, see, James Sylvan Owens, member in good standing, eligible to practice law in Florida. So right there, he is definitely in good standing and is definitely eligible to practice law. So there we go. Anyway, no, Kurt, this is the hearing that was 2 days ago. We're just catching up to it now. So all right, that is it. So let's be unburdened by what has been and proceed.
That interviewing her in the squad car was routine protocol to your investigation.
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question. Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions?
Now, look, people can be critical of James Owens, but he is a hero. He stepped up when nobody else would and said, I will represent her. He has been dealt a very, very bad deck of cards. Forget the individual hands he's dealt. Just his deck is faulty from the beginning. He's sort of been hamstrung from the beginning. He does not have a lot to work with. He is doing his best with what he has. Making these motions and arguing for these exclusions is something he has to do. So I praise him for doing this. So we can say, this is a dumb argument, this is a stupid argument, this is ridiculous, but it's got to be made. And he's the only one that would step up and do it.
You recall about what's this about, and you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Ooh.
Response.
This is the crux of the argument right here. This is what we're after. This is the meat on the bones of the lines. She supposedly did not read this mysterious last line of the Miranda card. And we talked a little bit about this the other day. The Miranda warnings differ all around the country. There is no Supreme Court decision that says you must say these exact magic words or else it's an illegal statement, an illegally obtained statement. It just says you have to advise them that they have a right to an attorney. If they can't afford one will be provided, that they have a right to remain silent, and anything that they say can be used against them in court. They just have to mention in some way those 4 things, and that's kind of it. I mean, the further you get from these core wordings, the more risk you're taking in giving it, which is why some of these cards are ancient, because it's always worked for a billion years. So why change the wording? So when he's saying, did you read the last line is knowing these rights or understanding these rights, are you now willing to waive those rights and talk to us or something like that? This objection that the prosecution made is going to be, that ain't part of it. You're required to advise them of their rights. You're not required to read this last sentence. That is not a legal requirement. I'm betting dollars to donuts. That's what he's going to argue. And I will take payment in dollars and or donuts. So win-win for me. And as long as we're paused here, we've got a lot of stuff to do here real quick. Gen X Gamer Girl. I feel like he's using the, is that your testimony, to attempt to intimidate this witness to think she did something wrong. That could be. And also it's the, well, you would agree with me, wouldn't you, that, well, no. It's the Jedi mind trick. Is that your testimony, or is it your testimony that, or you would agree, wouldn't you, that those are all legal Jedi mind tricks? She's trying to Jedi mind trick her. And Tanny Simmons says she sounds like she's speaking in questions. Thank you so much for Gen X for the $5, and Tanny for you. Yeah, she does have a little bit of an upspeak. She does answer in questions. And Terry Ann, first cop on the scene, we're bossing her around, in my opinion. Well, I mean, they were saying, you can't go back in the house and get your Dr. Pepper. No, you can't go back in the house and get your cigarettes. Just, sit there. You look like you're going to pass out. Have a seat in the grass. I didn't feel like they were really bossing her around. But yeah, opinions can differ. Aaron says, never touch the Gorilla Grip Pussy Pal without permission. No, that's a different phone. That was Hannah Gutierrez Reed's phone ID, not Sarah Boone's. Oh God, not Sarah Boone's. No. Different one. And totally not a Russian bot. Member for 17 months. Thank you so much. Oh, and Aaron, thank you so much for your 13 months. It's over a year. Coming up on the 18-month mark. Totally not a Russian bot. The gray, or gray for the fancy people out there, are only half human. If you know, you know. Insert X-Files tune in your mind. Iron Rabbit gifted 5 Legal Vices memberships. Dang. That must have been while I was searching and downloading the motion, the court's decisions. I missed that. If you got suddenly out of the blue very recently of gifted membership, that came from Iron Rabbit, and you should give Iron Rabbit a super special thanks, because he, frankly, or she, is an awesome person. You get a bell for that. All right, that is it. We've caught up. Thank you guys for the continuing ridiculous amount of generosity and love you're showing to me and the stream. We got 621 people here, 383 likes, like 250. You need to get down there and do your job. Hit that like button. I'm going to push play and have another drink of the official Sarah Boone Tang suitcase cocktail. It's the Boone Tang cocktail here. We got the Boone Tang suitcase is its official name. Vodka and Tang. Yum. By the way, vodka is just a nice way of making an alcoholic fruit drink, or in this case, a fruit flavored beverage. Let's go.
Judge, we're here on a hearing on the issue about the interrogation.
But the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card.
It's almost like I'm competent sometimes. It's almost like I'm smart sometimes. Wow, look at me. Exactly what I just said. And Gwendolyn, who's been a member for 6 months, says, lawyer, would you agree? You would agree with me? Me? Well, not in general. No. That's it. All right. Hey, lawyer, I feel seen. I feel validated.
Is in the motion upon information and belief. This is what it says. So how is it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But Judge, what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the.
There you go. This judge is awesome. I love this judge. He's like, you are making specific legal arguments about the sufficiency of the card that she read. Now you want to talk about whether it was policy or not? We're not talking about policy. We're talking about the law as you're arguing it in relation to the wording on the card and what she did or did not read. Pulling that guy in. This lady is the one that was doing the questioning on the videos, not the body cam footage, the one in the police station. So yeah, he's pulling her in. He's reining. I mean, not her. He's pulling the defense lawyer in with his arguments, going, "Hey, you're getting off the legal arguments here. Now you want to go talk about policy. Let's stay on track. You made specific arguments in your brief, and that's what we're here to talk about. Good on this judge." Bad Duck says Sarah Boone Tang. Phrasing. No, it's not phrasing. It's purely intentional. Trust me. There's a reason we're using Tang and not orange juice, specifically so we could make a joke about Boone Tang, because I'm 12 years old up here sometimes. It's our Boone Tang suitcase. Again, just vodka and Tang. All right, get back at it. This is going to be interesting. I want to see how the defense lawyer tries to get around the judge's restrictions on this.
The card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined.
That's a brilliant statement. The card is the policy, and the policy is the policy. Well, there's a term out there, if you're not familiar with it, called a tautological argument, which is it's circular, and that's the policy is the policy is perhaps the most tautological argument you could ever make.
Refer to each other. Our argument is that she did not waive her rights.
But
remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question
Mm-hmm.
about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not
See, and well, Special KL says, you still think he's he's a fantastic lawyer. He's a very, very good lawyer. Like I said, he's got to make these arguments. He has to. He's got to try everything he can possibly do to get that evidence excluded, because that interrogation was ridiculously damning. The video of her in the suitcase with the George in the suitcase is ridiculously damning. He's got to do everything in his lawyerly powers to try to get that excluded. He's doing the best he can with what he's been dealt with. So it's a great thing. Now, again, I'm going to only address this one more time. AZ Robert 007 says, James Owen has fees outstanding, so it shows on Florida site he's not able to practice in Florida unless the date is outdated and not updated. Interesting if the state and judge are not aware. We addressed this earlier. I will show this one more time. It's on my phone because I can't bring up the deal. Let's go here. Right. This is the only one time now what have I done? I've touched the buttons. James Sylvan Owens. There you are, sir. There, let's see. Wait for it to focus. Focus. Oh, why are you not focusing? Come on. There we go. I don't know if you can see that. Let's embiggen it so you can see it. This is the last time we're going to talk about this. All right, there we go. Come on. James Sylvan Owens, member in good standing, eligible to practice law in Florida. And if you scroll down further, you will see that There is, focus. There's 10-year disciplinary history. None. There is no disciplinary history. He is a member in good standing, eligible to practice law. That is the Florida Bar member profile. So just going to say he is in good standing and eligible to practice law. I've seen this a lot, and I have not seen anything otherwise. He is a very well-known, very renowned lawyer. It would be odd. So anyway, that's the that's the last time we'll talk about that today. Let's get back to the video here. See if we got any super chats outstanding while we're paused. No, sir. No, ma'am, gentlemen, ladies, people, we do not. All right. So he's doing the best he can. And, frankly, you got to go. You got to go with what you can go with. And he's making the best arguments he can under the circumstances. But the judge, again, I haven't seen the decision, but I'm putting on my amazing Kreskin hat. The judge is going to say something along the lines of, she has to be advised of her rights. That's what Arizona v. Miranda. There was Miranda v. Arizona or Arizona v. Miranda, whichever one it was Arizona and Miranda. Was she advised of her right to remain? She has the right to remain silent. Yes, she was advised of that. Was she told anything she says can and will be used against her in a court of law? Yes, she was advised of that. Was she advised that she has a right to an attorney? Yes, she was. Was she advised that if she couldn't afford one would be provided for her? Yes, she was. Was she asked if she understood those rights? Yes, she was. And she said yes. Then she talked. So she knew she had the right to remain silent. She said she understood that right, but she talked. He's going to say that last sentence that they're arguing about, whether or not, you have to say, now having fully understood these rights, do you fully and freely and of your own volition agree to waive these rights and talk to me? He's going to say, no, that's just fluff. They can ask, she can shut up. She didn't shut up. That's what I'm thinking is going to be his answer.
Ask that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names.
That upset the lawyer. That upset the defense lawyer. He's saying, look, he's Mr. Policy guy. There's a policy we just don't call people Sarah and George. We call them Ms. Boone or Mr. Torres. We don't just call people by their first name around here. We call them by their surname. So, but that made him spin his head around a little bit.
What matters is that the defendant was read what the case law requires.
Mm-hmm.
Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning
She
form?
read that.
Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you.
And so that's the argument. She didn't say, do you wish to talk to us at this time? Because she didn't read that, this whole thing should be thrown out. All this evidence should be thrown out. That's his argument. It ain't gonna work. But great try.
You're referring about surname. What do you mean by that? You mean
That means last name.
okay? What did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my memory card.
Oh, zing! Uh-oh. That's bad for the defense's argument. If you didn't hear that, it was kind of low. He's like, so did you read all 9 questions? No, didn't read all 9 of them. And then it was like, well, what about number 9? What, you didn't read number 9? Nope, number 9's not on my card. Well, there we go. That also hurts his argument a lot. This question number 9 was not on her card. The policy, if he wants to rely on policy, the policy is you should read the card verbatim. Apparently she did. That 9th question is not on her copy of the card. Oops. That shows you how unimportant that last sentence actually is. Well, dang. That hurt just a little bit, I guess. Well, I'm sure he's going to explore that further.
I'm sorry?
It's not.
I'm sorry.
What do you mean by that? It was the card that you read, it was not on the card?
There's that old adage. Do not ask a question that you do not know the answer to. He was completely unprepared for that little surprise of an answer. Yoink. Multiple Miranda cards.
But yes, that is in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get
Sustained.
did
Wow, that was an improper question. Somebody dropped the ball somewhere. Did you fail to do something? Oops. Yeah, she said, I followed the policy. The policy is to read the card. I read the card I got. Didn't have question number 9. Only had 8 questions.
Did you fail to get the most updated card, or how did
Objection.
that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being sex friends in 2013.
Have you become aware, as it relates to filing this motion,
I've been more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Irrelevant, exactly. Oops, that threw him off a little bit. That takes a huge chunk of the wind out of his sails. Bless the guy, he's doing the best he can.
When y'all took her phone, Detective, did you
Moving on to a new
Sarah
subject.
Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that.
Never.
I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her
Never.
calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
Good objection.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in.
All right. And what time was the autopsy that morning?
It starts at 8, but I did probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th date.
Yep.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that
Okay, this is interesting. The judge is giving him another chance. This means the judge wants to overrule the objection that was just made, but he's asking the question wrong. So he's giving him a chance to ask the question in a better way that won't get objected to.
they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What
cause.
does that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection for relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection for relevance.
Yeah.
Overruled.
Oh, interesting.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection for relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection for relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection for relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection for relevance.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
Good question here by Kiranoth. Why is the lawyer objecting against every question? The short answer is because every question is kind of bad at this point. He's fishing desperately to get, again, he's doing what he can. He's trying to ask the best questions he can. But under the rules of evidence, there's certain questions you can ask, certain questions you can't ask, certain ways you can ask things, certain ways you can't ask things, and you get to make the objections. If the question's irrelevant to the issue that's being discussed, you make the objection relevancy. If say he, if we need to do it, we should do a rules of evidence stream one day to sort of kind of go over like basically like the federal rules of evidence or things like that. But basically, if there are problems with the questions, you can object to the questions. Like earlier, there was a work product objection. Did you two confer about something? Did you and the other detective confer about something? The objection was work product, because you're not allowed to ask questions or elicit answers that deal with the internal discussions as part of your work. Anything you produce as part of your job, like meeting notes and things like that between people. That's work product. So, those kinds of things. Basically, he's trying to ask every question he can. They're not really great questions, but they're the best he can do under the circumstances.
He's right. Okay. Objection sustained. Okay.
So, there we go. He's right.
Okay. Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Okay, they're making the best evidence objection, and which is basically you have to rely on the best evidence available. So let's say you have a copy of a document and the original of the document. Let's say you have a video, for example, and one video is a copy with a watermark, and the other video is the original video. The dogs are snoring up a storm here. If you submit the copy of the video, then the objection could be made. The best evidence should be submitted, which would be the original video or the original of the document. That should be submitted because it's the best evidence, not the copy. And of course, you can get around that by going, okay, for whatever reason, the original is not available. This copy is the best evidence that we have. So that's why we're submitting it. Here, he's talking about things that are on the video. He's asking her to, did you say this? Did you do this? And the prosecution is saying the best evidence is the video. It's on the video. So you submit the video and then we can have the argument, essentially. Again, the defense lawyer, it's a tiny little spark of hope out there, and he's desperately reaching, trying to get it. It's an incredibly difficult thing to argue, specifically because she signed waivers. She said she understood her rights, but she continued to talk anyway. So this is anyway, we're kind of getting far afield here. But that is what this best evidence argument is. They're saying the video is the best evidence of this discussion, not her answers here on the stand.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Overruled.
One more time.
Yes, the judge has made his ruling. We'll read the rulings at the end of the hearing here.
I assume that's not the first time you've read Miranda to a suspect.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013.
How long have you been a homicide detective?
Over 6 years.
Okay. Have you ever been trained or told to ask or not to ask Any statements or any questions prior to reading Miranda relating to them talking to you?
Objection relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection relevance.
Overruled.
I did not ask for question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
The one without question 9. And we have an Aussie Overlord raid. Welcome, Aussie Raiders. Great to have you here. Welcome. We've got 707 people here right now, 460 likes. So smash that like button on your way in. We need about 250 of you to do that same exact thing. Smash that like button and hit the subscribe button. We're just getting underway here. And spoiler alert, Sarah's taking the stand very soon. Any more questions, counselor? Because, Hayden, we got a lot of stuff to do. We've still got half the hearing to go through. Exactly half the hearing to go through. Then we've got the judge's decision, which is 13 pages long. So we're going to be here a while. So strap yourself in and hang out with us, everybody. We'll bump it forward here a little bit until they start talking.
Yes, this is our waivers and affidavits.
Is that filled out, the waivers and affidavits?
It's filled out.
Counselor, do me a favor. Go back to the lectern where you were and speak into the microphone. You're annoying 723 people who can't hear you right now. Oh, and as long as we're a pause 200-watt studio, how you doing? Welcome. It's Ben and Bennett. Who's the hottie on the stand? That's the defense lawyer. The lady next to him is the interrogating officer.
By me, but there's something highlighted that I did not do.
Is the form filled out as it relates to Sarah Boone?
Right. Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Is that her signature? Yes.
Yes.
Jeez, dogs.
Yes.
And is that the consent for the phone?
The consent to search, yes.
That's the consent form to search her phone.
On that form, is there also the recording ordinance?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read or remind from that, from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
You would agree that there's 9 questions on the form?
Yes.
Okay, again, he's making a valiant reach here. He's making a valiant effort. He's like, okay, because on this waiver form is the Miranda rights with all 9 questions. And her Miranda card she read from only has 8. So it's like, so you didn't read from this document with the 9 questions. And he's kind of pressing her on that. Why didn't you read it from the one that you see right here? It has 9 questions. You didn't ask that 9th question. He's reaching desperately. It's just not far enough, I think.
From this piece of paper? Yes. That's audio and video recorded? No.
You would agree that there's 9 questions on the form?
Yeah.
You would agree that there are 9 questions on that form. So he's going to offer it
Same
into
objection
evidence.
to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Good response.
To paraphrase that lawyer, ain't nobody got to read that answer. Ain't nobody got time for that.
Judge,
You don't have to read that
obviously
question.
we disagree.
Then where's the case that supports that?
This judge is fantastic. He's like, well, we disagree. Okay, so where's the case law that supports your disagreement? We know you disagree. That's why you filed the motion. But where is your legal support? Where's the legal support for your motion? That's what we want to hear. Give me the legal arguments. Chloe Albert's revenge. Oh, she does look like Casey Anthony. No, she looks like H3H3's wife, Gila. More than Casey Anthony. And like she's about to break into Sharon Tate's house. No. She's angry because they're calling her a loser of a cop who should have all of the evidence she collected thrown out. So she has a right to be snark-filled. So, okay, let's hear what his legal argument is. What's his case law here?
Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell?
I'm just going to say, if you ever happen to find yourself a lawyer, being a lawyer and being in front of a judge, and the judge says something like that to you, you're in trouble. You're not going to win your argument. That's just going. I've read every single thing there is to read on this subject, and none of them say they have to read this mysterious question number 9. So, what do you got to say for yourself? What was the question number 9? Question number 9 was, do you, now that you knowing these things, do you agree to talk to us? Yeah, he's saying, nah, nobody requires us to say that. So, what do you want me to do here, counselor? It's a bad situation to be in. He's telegraphing that you ain't gonna win this, counselor, unless you pull a rabbit right out of your hat.
And then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Exactly, Judge. I mean, you're my soul. She was read her rights. The question whether she wants to talk and waive those rights, that's not a right. She was read her rights. Do you want to waive your rights? Is an extraneous question. If they ask a question and she talks, she knowingly waived her rights. So yeah, he's saying, yeah, that ain't a right.
I want to finish my argument.
Okay.
Sorry.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak
Her
to
talking
you now.
is the waiver.
So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights. Do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider.
There should be a consideration the court should consider. See, now he knows he has a losing argument. So he's saying, I know what you just said, Judge. But then he wants to bring in this totality of the circumstances, or the legal penumbra is another great word to use that lawyers like. He wants to bring all the, but let's look at the big picture here. Let's look at the big picture, Judge. That's a really important question, I think. And he's essentially asking the judge to make some amazing changes to the Miranda warnings. Again, long shot, but he's got to make the argument. He's making it as best he can.
I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
Again, fifis, that ain't your greatest argument. I feel like it. Well, Supreme Court judges feel otherwise.
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas.
Oh my, I'm going to be right back.
Southern Third 197 and Owens 41 Southern Third 352. There's it's not relevant as to what the questions need to be asked for the purposes of whether sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
Of course that would happen while I was gone, wouldn't it? Of course that would happen. No, that's not me. That's them. See, we still have the law and crime thing here. Of course that would happen. The 30 seconds I'm gone. Been over an hour and 25 minutes, an hour and 44 minutes on stream. All right, we're back.
on the 25th, when you were reading her mind and about to question her, was different from
we
the
still don't have
situation
audio.
the day before.
This is not me.
when
It's
you
on
read her
them.
Miranda in the squad car.
Ooh, fancy.
Yes, I had more evidence.
That was without the autopsy.
Now let's see if we skip ahead a little bit, see if we get audio back. Sidebars. Oh no, is this a me thing?
By both, yes.
Huh. All right, that's
Anything else,
odd,
Mr.
isn't it?
It's essentially the defendant stating that they
Okay.
want to make new case
Hang
law.
on. Because you can hear it, but I can't, clearly. So let's do this. Give me one quick second. Copy paste. All right, there we go. This should work. Let's see. We got to go to 127 is where we were. It was fine for you, not for me. That's right. And I want to hear it too. It's that thing with the widget where I try to boost the volume, which does nothing for you, but apparently does something for me. So I just turn the widget off and we get our volume. We get our volume. Well, I get my volume right back.
All right, redirect.
That's it.
All right. Can this witness be released?
No redirect. So he's like, yeah, Judge, you kind of made our arguments for us. So thanks. All right, let's we get some Yoda action here. There we go. Okay, so that look, that ain't the motion is not going to be granted. Like that little lecture that the judge went on about I've read all the case law. Ain't nowhere does it say that we got to read that. That was your big clue how this is going to end. Well, let's see what the next witness can tell us about this situation.
I'd like you to stay.
All right, subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. Awesome.
See, and again, this is the defense's motion to suppress this evidence. So it is the prosecution. The defense makes the motion, so the prosecution has to call their witnesses against the motion. They're like, yeah, we just need the one. She told you everything you need to hear. Got no more evidence, got no more witnesses. Now the defense gets to argue in favor of their motion by calling their witnesses. And before we do that, Jacob says Sarah Boone looks angry. Have you ever seen Sarah Boone not look angry? She has resting murder face. just saying. 200 Watt Studio also says thank you so much for the additional $2. Says she can interrogate me hard and I will be. Shame on you. Shame on you, 200 Watt Studio. 708. Oh, this is a good time for a midstream grift here real quick before we call our next witness. 718 concurrent viewers. What we're going to be doing here is there is still 1 hour left on this. When we finish this, we will go immediately into the judge's ruling on these motions. They were just posted a very, very short time ago. I have them all downloaded now and ready to go. So immediately upon the conclusion of this, we will begin reading the decisions, which take a total of 13 pages. We'll probably be able to skip a lot of it, but we will read them immediately following this. So stay tuned for the outcome. 742 people, 538 likes. We need to be to 700 likes. There is no reason we're not at 700 likes right now. Well, there's no reason we're not at 742 likes either. But please do me a quick favor in the next 30 seconds while we're on this little 30-second cleanse. Hit that like button, hit the subscribe button if you haven't already done so. We are edging our way so close to 81,000. Last I checked, we were 360 away from 81,000 subscribers. I want to be to 81,000 by the end of this trial. We can do this. March to the silver play button. I would be just absolutely tickled 6 shades of pink if you would subscribe to the channel. And if you are subscribed, double check to make sure you are. Now we do have our like and subscribe poll, which is just to remind you to do those YouTubey things, like and subscribe and all that. Let's see how you're answering so far. How should Sarah Boone be restrained during the trial? That's another motion we're going to be hearing today. We're going to hear a motion that she wants to wear lipstick and another motion on how she should be restrained. So how should Sarah Boone be restrained during this trial? 7% of you say only leg irons. 9% of you say she should be restrained only with cuffs and leg irons. 24% of you says she should be restrained with a shock bracelet. That's acceptable. And 60% of you say she should be restrained by being zipped in a suitcase. Those are your choices if you haven't already done so. Take our like and subscribe poll after doing those things. Thank you very much. Now, we've got the palate cleanser out of the way. We've got the emotional support potato pig dogs for day 28. That's pretty awesome. All right, let's continue with our next witness.
All right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
And while they're figuring what to do, for those of you that have seen or heard the judge's ruling, no spoilers in chat, please. Let those that haven't heard it find out for themselves at the end of this stream here. Thank you very much. No spoilers for how this was all worked out, even though I pretty much am going to be 100% accurate with my guesses.
Just that
All right, let's go.
It's been marked as defense exhibit.
Okay, he's putting his evidence into exhibit. He's putting his exhibits into evidence.
Now, or is it the,
It's irrelevant.
He's objecting to
is it
the submission
form
of the
as
evidence
now,
being
or is it the form
irrelevant?
as of 2020 when the? Okay. Can I see it for a moment, please?
All right.
Objection for the same reasons the court articulated previously.
All right, just get it into evidence. Get your objections out of the way.
Additional-
Here we go.
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
Come on, move it along, Charlie.
Those policies are on.
All right, getting the
Is
policies
it
in.
beginning of paragraph 4, waiver of constitutional rights?
Yes.
I'm sorry, Yoda. Are we disturbing your sleep? Are we disturbing your sleep there, buddy? All right, get those bad boys into evidence and let's move this thing on.
Read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
All right. While they're figuring all that out, we want to welcome Bad Weather Biker back to the clean and sober crew. Thank you so very much, Bad Weather Biker. Glad to have
Anything
you
else?
back as a member.
No other argument, Judge, other than what we've talked about.
Anything further?
Same arguments.
Okay. All right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be received into evidence. Over objection as states 1. I'm sorry, defense is 1.
And I wish I was drunk with the €2. Hey, Jeff. Hey, chat. Remember me? Good to see you. Good to see you. I wish I was drunk. I'm working on it. We have almost completed today's Boone Tang suitcase cocktail. Vodka and Tang, the Boone Tang suitcase, I've called it. Because I'm childish sometimes. Oh, I'm sorry, Yoda. We've disturbed your
Any
rest.
further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Yeah.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
Even Yoda's hyperventilating to hear Sarah Boone testify.
Judge, I'll be here.
Yes, sir.
And
And
while,
the deputy's got to move her.
while the deputies are moving her over there, Vince Clortho, member for 14 months. Thank you so much for the long-term support, Vince. The keymaster himself. Asking a favor, please explain man, bear, pig to Danny. I heard that. Yeah, chat was talking about Bigfoot v. Sasquatch, and I mentioned it from South Park. She'd never seen it. Yeah, I saw that. That was kind of funny.
Ma'am, you've already been sworn.
Ladies and gentlemen, Sarah Boone is now going to testify. Now, I want you to compare and contrast her statements with what we heard on the body cam footage 2 days ago and what we heard during the police interrogation yesterday. You may notice a few contradictions. I'm just saying. Let's see if she's straight down the line or if things may have been said differently.
Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
That is not
You're
her
going to have to
phone
speak up or move the mic.
Sarah Boone.
Yes.
Her middle name is like Catherine or
Are
something.
you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
And Carla Riley says, isn't there body cam footage? Yes, we watched that 2 days ago. We watched it 2 years ago, and then we watched it again 2 days ago. If you go back into there's a Sarah Boone playlist, just right up there, body cam footage, you can't miss it. Sarah contradicting herself? Shocked. Well, let's find out if she does.
What mental state did you have at that time?
Very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son.
And she, as far as I recall, she never once mentioned her dogs or her son in the body cam footage.
I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. She
was hung over, she said. Well, she said we had one bottle of wine and there was some left in it. That was her. And then during the interrogation in the police station, she said, I don't drink, but he does. I can't get drunk. I don't want to get drunk. I was not drunk. I was not drunk. She said that many times during, plus that's only a few of the times she said it. She insisted she was not drunk. Now she's saying she was confused and hungover from not being drunk, apparently.
still, I believe, intoxicated to a degree.
Objection, Judge.
She was still intoxicated when she adamantly said, I cannot get drunk. Now she was still drunk. Gosh, I think it was 13 or 14 hours after she said she basically had half a bottle of wine and fell asleep. So half a bottle of wine, she's still slightly intoxicated, but also has a hangover at the same time, 14 hours after she drank the wine.
I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Good.
We're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay.
That was actually a very good objection, a very good ruling by the court. Okay, this might be interesting, but this ain't the subject of your motion. You have to be very, very specific with what you're arguing, and you never mentioned any of this in your motion to suppress. So move on, counselor.
This is the day before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Yep.
It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained and it's stricken.
That's also kind of fun. So you can't make this argument. Are you making the argument? Yep. All right. Objection sustained. No, you're not. Move on.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you
Is that like my dad telling, he said, I'll tell you where to go and how to get there? Or are we talking about something different?
explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesall?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Hopesall told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about
I hope I don't
something
miss
regarding
anything. Be
keys
right
for
back.
me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
You're eligible.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
Did I call for a yes or no? She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did
Uh-oh,
he
he
escort
was
you
trapped.
upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
Oh no, he was wearing a fuchsia shirt. I know that for a fact.
And they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
It doesn't matter, right? It doesn't matter how she felt.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? Could you said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Well, tough titty, as my mother used to say.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody.
Totally irrelevant.
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Oh, zing. Zing, judges striking again. She was in custody. Well, she didn't know she was in custody. Well, who the F cares what she thinks? She was in custody whether she knew it or not. Judge. Mwah. Have a lawyer crush on the judge.
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
She didn't think she was free to leave and she was in a enclosed space. That means she was in custody. If she didn't know she was free to leave, then that means she must have thought she was in custody. I'm getting Muppet voice again. Counselor. To banish the Muppets. All right. She didn't know she was in custody, but she thought she was not free to leave and she was in a small enclosed space. Yeah, if she didn't think she was free to leave, that means she thought she was in custody. Sorry, counselor.
She was.
That all goes to whether or not.
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm.
As police normally
She was
do.
trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
subjectivity matter under the case law.
Based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
All right. Now, again, if you ever find yourself being a lawyer, and you're desperately grasping at straws, trying to find something to help your client out, and the court asks you what your legal basis for your objection is, and you say, well, I believe it's relevant, he ain't gonna win. What he believes and thinks ain't important. It's what the law and case law say. So God bless him. He's not in an admirable position, which is probably why no other attorney in the state of Florida stepped up to do what he's doing. He knows he's in a horrible position. He knows he's only had 2 weeks to prepare for trial, but he's doing the best he can. He makes the argument. He gets pinned on the legal grounding. He's like, well, I believe it's relevant. Yeah, sorry. Objection sustained.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Oof.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
Did not.
And look, now this is a trick that's as old as the universe. And again, we all know or should know that the police are absolutely allowed to lie to you. And this is so common for the police to do that. When they want to do like a criminal roundup for people that have skipped bail or not showing up for hearings, people with if they want to do an outstanding warrant roundup, all the time you'll hear of police officers who get these crazy ideas like, hey, let's send everybody that has an outstanding warrant, we'll send them an announcement saying that they've won a super special prize, and tell them that they should meet at this location, at this company or at this warehouse on this date at this time to collect their prize. And the dumb ones go, wow, I got free things. And they all show up at the warehouse. Then badges come out. Hey, everybody that came here to get the free stuff, just kidding. You're all under arrest. That's essentially what they're doing to her here. Look, why don't you come and pick up your phone? Wink, wink, wink. Okay, I'll come and get my phone. Oh, by the way, you're not getting your phone. There is nothing wrong with this from a legal standpoint. It's ethically shitty, and I hate the cops can lie, but legally, there's nothing wrong with it. So yeah, this is a cop trick as old as cops. Let's just tell them they want an 85-inch I guess we don't do plasma anymore. QLED TV. And they show up and you go, just kidding, no TV for you. And they arrest you.
Did you know that you were going to be arrested?
Doesn't matter.
Did you know that you were going to be questioned?
Doesn't matter.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
Are you shitting me right now? Are you kidding me? When Deputy Rodriguez arrived at your house after 1 p.m. the next day, you were under the influence? Now that has a legal meaning. That means above the legal limit or otherwise impaired. Again, this is over 13 hours after she went to sleep, which she says she stopped drinking at she went upstairs around midnight. We don't know what time they stopped drinking. Let's give them 11:30 they stopped drinking. So essentially 14 hours before the cops showed up, she had half a bottle of wine and was still under the influence of alcohol 14 hours later when the police arrived on scene. This woman who is still drunk on half a bottle of wine 14 hours after the incident is the same one that the following day in the police interrogation said, "I cannot get drunk. I was not drunk. I was not drunk. I didn't want to get drunk. I don't drink. He does." That's the same woman. Ugh. A little bit of a contradiction there, Sarah. That's a little bit of a contradiction there. Just gonna say. So the woman who can't get drunk was also drunk 14 hours after she went to sleep.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect?
Sarah, he's trying to help you. He's not going to ask you a question to which the answer is no. He's desperately trying. Oh, it's a bullshit answer you're going to give and a bullshit question. He's trying to help you. Just say yes. Yes, say yes. I was horribly impaired, sir. Don't try to outthink your own lawyer. This is such bullshit.
My answer?
I don't think she understands.
I don't.
How do you not? She's smarter than everybody. She got straight A's. She told us that yesterday. She excels at everything was her exact quote. But yet she doesn't know this. Did the alcohol impact your ability to think clearly on that day? How does she not understand that? Triggered.
It's been asked 3 different ways.
So we'll leave it at.
Asked 3 different ways because you won't fucking answer the question. That's a Muppet voice. She's The question has been asked 3 different ways because you can't seem to figure out what this really simple and straightforward question that your lawyer is asking you in a desperate attempt to help your ass is not being answered. You're not answering it.
You were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
All right. Again, this is another cue. The judge wants to sustain this objection. He's like, okay, I need the legal grounds here. Come on, give me the right legal grounds, and I will sustain your objection. So choose your legal grounds for objecting carefully, counselor.
I know that she said she didn't know what.
What are the legal grounds of your objection?
He's not going to get it.
I'll withdraw it.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire.
Oh, wait. Did they switch lawyers while I was gone? Well. Then ignore everything I just said. Okay, that explains a lot. All right. Sorry. They must have switched it up when I was gone. Sorry. They sound actually quite a bit alike to me. All right. I want to go back and watch the last 5 minutes with a new perspective, but we won't. All right. Never mind. All right. Rewind. Sarah, nobody believes that you don't understand this basic, simple question. Hey, that's kind of the same thing I was saying. Just this guy is trying to nail you to the wall on this, but nobody's believing that you don't understand the question. All right, there. How's that? Is that better? Sorry for the confusion, chat. That's embarrassing. Nobody told me they changed sides.
Desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge, I would object to that. I'm not understanding what the question.
Okay, now I can hear the difference in the voices. Okay. Yeah, I was I was still going full steam ahead with the direct questioning. Again, my apologies, and can't wait for all the comments on it. What are you talking about? Sorry. Hope everybody waits until they see this part before they comment and tell me what a dick I am. All right. I know I wasn't looking at chat. I was doing my job and paying attention to what I thought was the defense counsel asking questions. All right, here we go. My brain has been realigned. I'm now back. I'm back with you guys.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Kopsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is.
Okay, now, had I let it play for one more question, I would have realized my mistake. Because he's basically saying she's bullshitting it. She's giving answers that are biased in her favor because she knows that if she says these things like, oh, I was drunk 14 hours later, that it could influence things in her favor. So basically saying she's lying. Very, very tactfully, very, very politely saying she's lying so that you will treat her answers more favorably and rule in her favor. She'll say anything it takes to get this evidence excluded. That's essentially what he's saying. She's playing fast and loose with the truth.
charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1. And therefore, she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road.
I need an ashtray. Hang tight.
About what she said there versus.
And let me know if they change while I'm gone.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table while she's in the process of returning to.
Okay, I heard the ending. my cleaning lady hid my ashtray. She moved it to someplace else.
Counsel's table. Anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we can proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
That's one thing I like, and I'm sure this guy says voir dire too. I can just tell because he's smart. That's one thing I like about the true Southern people, because we say y'all in Utah occasionally. Y'all finds its way into Utah, but it's singular and plural. There's, y'all meaning you, and there's also y'all meaning everybody. But the South, I like that. There's y'all, which just means you, and then all y'all is plural. So I really like that term, all y'all. That's I've started using that, and hopefully I'll be able to change Utah when I use it every time I go on vacation. So in Utah, y'all is singular and plural. Refers to you, like sheep and sheep, refers to you and everybody around you at the same time. And all y'all means everybody, and y'all is singular down there south way. I just find that an interesting linguistic thing. Now it can also be singular or plural in Georgia. Right. I like all y'all, but I'm lazy, so I say y'all. Okay. The closed captioning got it right too. Yes, it did. All y'all is plural and proper. Please be sure to use it correctly. Exactly. No, it isn't, Hayden, for reasons. For reasons that maybe may be difficult for foreigners to understand. Y'all is singular everywhere. But some places y'all is plural, but all y'all is plural in other places. Anyway, let's go. We got 636 likes and 800 people watching, so let's get a couple more likes. Special KL says, "Are you streaming this trial?" Of course I'm streaming this trial. That's what we're doing now. We are in the run up to the trial. I will be covering it all the time. So do not fear. Just be here for the Sarah Boone trial with me, Legal Vices, the most amazing, wonderful, and best law fluencer on the interwebs. I am the Law Rex, the Law Tuber extraordinaire. But follow me. Just watch the trial here. We'll have fun. All right, let's hear these arguments here. All y'all got.
Mr. Owens, it's your motion, sir. You may proceed.
What a lovely cigar.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that should be allowed or is allowed. There's nowhere in the law that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened.
Well, I would argue there's a difference between we have to talk to you and you have to talk to us. I would say if he said you have to talk to us, he might have a better argument. But saying we have to talk to you, I don't think that's such a strong argument.
But that's the implication this detective gave Sarah Boone.
Exactly, Swan Lake Lady. Great minds.
It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you.
Oops.
So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion?
Well, there's
I mean,
no
we're sitting
confusion.
here
You're
Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
They can do that.
A traumatic event. She lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you.
Ooh, that's called.
We just need to do it.
Can do it.
And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be
Yes, this is
a
Sarah's
valid
lawyer, right?
waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Copsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us?
Now, counselor, I like you. You're admirable. It's a fantastic thing that you're doing here, but no. Now, that's not the paramount question, whether you want to talk to us. Now, the paramount question is, do you understand those rights? She said, yeah. So you have the right to remain silent. Do you understand that? Okay, I'm going to ask you questions. You don't have to say now, I've told you don't understand. I've told you have the right to remain silent. You've said you understand you have the right to remain silent. Now, do you want to talk to me even though you understand you don't have to? No, she said, do you understand you don't have to talk to us? Yes. All right. And they can ask questions. You're a great lawyer. You're fantastic, and you should be praised for doing what you're doing. But yeah, this ain't gonna work. This ain't gonna work.
That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Copsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement.
Yeah.
She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her.
Yeah.
If she came and said, I want to invoke my rights, she was going to be arrested.
Yeah, so?
They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Well, thank you very much, counselor. That was a really, really good effort. You get an A for effort, but it ain't gonna work. Jacob with a $5. Sorry for reading this so late. I think I can hear the DA salivating about getting a chance to question her. Me too, and I was gone when it started, so I was confused for a minute. It took me a while to figure out what was going on. But yeah, he was chomping at the bit, I guess, or champing at the bit, if that's what you say. Chaos coordinator member for 23 months. One more month and it's a year, 2 years. This is going to be one hell of an interesting trial in many ways. Thanks in advance for streaming this, Jeff. Thanks in advance for watching Chaos Coordinator. And thank you in advance for the 2-year, 24-month membership that's going to happen. Thank you very much. All right, let's hear what the prosecutors have to say.
Any response?
Now, it may be a bit simplistic. It may be a bit crass, but my argument would basically be what I've been saying. Your Honor, she understood she had the right to remain silent. She understood she had the right to an attorney. She understood that anything she said could and would be used against her in a court of law. She understood that if she couldn't afford a lawyer, she would be given one. She understood this because she explicitly said she understood it. She understood that she could have been silent, but she talked. And then I'd sit down. Maybe that's overly simplistic, but that's kind of what I would do.
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. Mm-hmm. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
Okay, that was actually much simpler than mine. I'm surprised by that. That was actually a much simpler argument than mine. He said, hey, the Supreme Court doesn't say she has to say it. And see, Jillian, that's what I was going to say. She wouldn't have zero motivation to be dishonest. You know, she does want to get her arrested. She does want to get the indictment. Yeah, I was going to call him out on that too, but wow, that was much simpler than I would have. That was like the Supreme Court doesn't say we have to do that, and she's not credible. Bye. Okay, that was a lot simpler than the one I was going to make, but I do agree with Jillian that yeah, cops kind of always have a little bit of a motivation to lie, which is why they can legally do it. They have such a motivation to do it that they can legally do it. And what do we got here? Mary Jane, not really Sarah, member for 5 months, says, Jeff, take your vitamins. Well, thank you. I will. Bernice Conklin, member for 15 months, says, wow, time flies when you're having fun. Thanks, Jeff, for everything you do for us. Well, hey, and hell no, we got 766 people here in chat. Thanks to all 766 of you here in chat for what you do for me. Seriously, from the bottom of my heart, thanks, guys. Jensen with the $5. Once again, only if there wasn't a live stream. Feel bad for her defense lawyer. Yeah, I feel bad for the guy too, but he knew what he was getting into, yet he still decided to do something that no other lawyer in the state of Florida had stepped forward to do. So big ups to him for doing that. He wanted an extension. He didn't get an extension. He has to deal with the cards he's been dealt. That's a policy is policy argument. You got to deal with what you've been dealt. And he's doing the absolute best he can. He knows it's weak. He knows it's a ridiculous stretch, but he's got to do it. And, kudos to him for even making an attempt. Crystal Ponzak, she is the most intelligent person in the room, after all. Member for 13 months. Thank you. Yes, she's a straight A student. And as she told us all yesterday, I excel at everything. Yeah, her own words. Nikki MCR Mama, not to mention that she herself had questions for them and went into the interview willingly. Fact. Okay, people. Let's continue, shall we? Get me to 700 likes, peep. We are 29 likes away from 700. Come on, peeps. Let's get it to 700 likes. Only 29 of you have to go down there and smack that like button. Do me a favor and do that. And as long as you're smacking the like button, hit the subscribe too if you haven't already done so.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow.
And
courthouse may be closed, but I'll be here working.
We have that ruling, and we will be reading it as soon as this hearing wraps up in approximately 20 minutes.
Judge, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
To the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Yeah, that's what I'm thinking. We all agreed before, and Sarah already agreed that when the trial starts, she'll be allowed to wear civilian clothes. She will not be handcuffed. She will not have leg irons, but she will have a shock ankle bracelet. We've already agreed on this. Why are we talking about this again?
Response.
Judge, I just want clarification, but she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other two lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection,
But counselor, she's already agreed that she wouldn't have leg restraints. She's going to have an ankle bracelet. I don't know why we're talking about this. This is weird. Yeah, this has already been discussed, Marco True. This was several hearings ago, and that was what the judge said. We'll put a shock ankle bracelet on you. It's up to you. If you wear pants, they won't see anything. If you wear a skirt, they'll see you have it on when you walk up to the jury stand. So it's up to you to decide what you want to wear. We've been over this. He's arguing something that doesn't exist. All right.
I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when...
You don't think she's a threat? She'll have a pen or pencil with her. I've seen John Wick. I know what you can do, what one person can do with a pencil. Just saying. And look, by the way, I agree 100% with everything he's saying about the fact that she shouldn't be in handcuffs. And if she takes the stand, she shouldn't be in leg irons. And they've gone to great lengths because when the jury leaves, when the jury comes back in, everybody stands and everybody sits down. When this was back when she was acting as her own lawyer. The judge was willing to say everybody stays seated when they ask their questions. Everybody, he made all these concessions. He made all these concessions to her. This has already been decided. But as I was saying, I completely agree with everything he says about potential prejudice in having handcuffs and leg irons if someone's moving around. Jurors see leg irons and handcuffs, and it does influence them. And that's fairly well established that, they unless they are some sort of serious potential risk. Hell, same goes for Daryl Brooks. Thank you for your great legal analysis and dog cam. Well, probably more for the dog cam than my stunning legal analysis, but I'll take it because I am the lawfluencer extraordinaire. So again, I'm in agreement with the lawyer. I just don't think we need to be making this argument because it's already been resolved with a perfectly reasonable agreement for the ankle bracelet. But thank you again, Steve Keat, for being a member for 1 month, and Atomic Squid with the $10. I can't help but feel a little sorry for the defense counsel. The guy has a Sisyphean job with a boulder for a client. Just keep rolling Sarah up the hill. That's you got to do that for eternity. Thank you very much for the super chat. And Dave Edwards, she has a pen. Exactly. John Wick. We know what can happen.
Criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. Mm-hmm. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay.
Police.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to provide, get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning, each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard.
I like the prosecutor's like, I don't give a shit. It's weird, but if she wants to wear makeup, go ahead.
To the clothing, you can perhaps someone attend, travel to the jail with you, sir.
Pop Sugar, thank you so much for the spoiler. We were just going to get to reading that. Yeah, thanks. No spoilers in chat, please.
Mr. Owens, to take the measurements, you'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the
courtroom. Oh, well.
Yes, sir.
We can't put the restraints back on the defense.
The last item teed up for today is I'm sorry. Yeah.
Yes, it's okay. We have a gift purge. And while they're quiet, we will purge with gifts. Steve Keat, member for 1 month, has also just gifted 5 Legal Vices memberships.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see
DOC and
could be LED. Can't believe I just said LED. Never mind. We'll say it could be acid laced makeup, LED. Could be LSD laced makeup. Who knows? But Steve Keenan has gifted 5 Legal Vices memberships. Also, Jenny LJ has gifted 5 Legal Vices memberships. So if you happen to be Jonathan Irwin, Maud, Barton Bella, CD. Oh, Jonathan Irwin, you're already a member. Never mind. Maud, Barton Bella, CD, General T, and Christine Perkins. If you happen to be one of those 5 people, make sure you give Steve a super special thanks. And if you happen to be Jenny LJ, recipients are Derek Rosborough, Rachel K, Kim. Wow, Kim's lucky today. Lancelot 652 and Black Horse Cavalry. If you happen to be one of those 5 lucky people, give Jenny a super special thanks. Thank you very much. Now let's get back to this LED laced makeup she might have on. Yeah, who knows? It might be LSD laced. Ooh.
And sheriff's officers tell me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail.
Yes,
facility.
It's Friday. My blood alcohol content is dangerously low.
Okay. All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need more. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, and said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Relating to me subpoenaing the enlisting the I think it was
it's the third amended witness list lists certain people as witnesses: custodian of records, Orange County.
Hey, we got 708 likes. Thank you, everybody.
Supervisor for the office of the state attorney.
Thank all y'all.
Supervisor for the office of the state attorney, and misdemeanor supervisor for the office of the state attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of jail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
as to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Just like, okay, all right, whatever.
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, as by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay, all right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. Paul's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2. And then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that. So.
Okay. If you go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow. But based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all. Which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case.
See, well, he took the middle ground between voir dire and voir dire. He said voir dire. That's kind of cool. He took the middle ground. It's that's very politically correct of you, Judge. But we both know in our heart of hearts it's pronounced voir dire. But I'll take voir dire just to keep it even.
Days. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay. All right. Thank you all very much. We'll see you Monday morning at
interesting.
9 a.m. What's the recess? Thank you.
Okay, that's interesting. That's an interesting scheduling thing there. So what they're going to do is they'll come there Monday for getting the jury. They said they're going to make a motion in limine to exclude their battered spouse expert. So it sounds like what the judge is going to do is get the panel set up and then tell them to come back later in the week. And then they'll spend a day or however long it takes to argue this motion in limine and the other final motions. So interesting. The actual trial might start towards the end of next week. So we're just going to have to play this by ear to see what they do on Monday. Huh. Well, there you go. Okay. That's an interesting scheduling issue. That again, we'll just have to figure out how they're going to do it as they do it. So stay tuned to hear. So, wow, 4 years goes by so fast. It does, doesn't it? All right, we are going to look at the judges' rulings now. So do not leave, 720 people that are here. We have 726 likes, and before we get any further, I just a couple of minutes ago got a notification that Superman D What right here in chat. Everybody throw up a D What in chat. D What just dropped by Cash App $100. He just dropped a $100 for 700 likes. D What, you get several things here. You get the foghorn for that. Oh, hell yeah. Thank you so much for dropping the $100 for getting to 700 likes. And you get a shot for that of 16-year Glendronach single malt scotch. What a fantastic whiskey that is. D What, thank you, brother, for that super, super generous super chat. Well, the Cash App chat out of the blue. Thank you very much, brother. You are awesome. I deeply, deeply appreciate it. Cheers. Dang. We have Mariko saying, "Ugh, I have the feeling that my great-great-grandchildren will still be watching these pretrial motions. Hopefully they'll be finished by early next week." prosecuting a victim blaming. Yes, she's going with a battered spouse, self-defense, battered spouse defense. But you know, if I was potentially facing the rest of my life in jail, I'd be blaming the shit out of the victim too. If that was an option, you know, got to try whatever it takes to make sure you don't spend the rest of your life in jail. You know, it's a crappy argument to make. It's shitty, but hey, nothing wrong with it. And I would do the same thing if I was a murderous person who didn't want to go to jail for the rest of my life. Autumn Locke says the makeup issue is dumb. If the ladies are willing to apply it quickly and they keep it, it's not contraband, just requires her to wipe it. Well, what they were saying is they don't know what's in the makeup. They don't know what's in the makeup. You know, there could be LSD in the makeup. There could be GHB, you know, contact drugs in it. They just don't know. So that's why they're saying that. And that takes care of the comments that we have so far. Now let's remove the court video. By court video, we'll see more of you on Monday. Wait, the dogs have disappeared. Yoda has shifted. Yoda is awfully darn active today. Now, what we're going to do is look at the motions here. Oh, good night, Yoda. Yoda, my dog fell down. Okay. Present. Silly dog. Present screen, share screen, window, PDF. There we go. All right, Yoda, we're going to put you to sleep here. All right, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number Division 20, State of Florida, plaintiff v. Sarah Boone, defendant. Order on defendant's motion for right to hair, cosmetics, and civilian clothing without restraints for trial. This cause came before the court on October 2nd, 2024, on the defendant's motion for a right to hair, cosmetics, and civilian clothing worn without restraints for trial, e-filed on 9/27/24. The court, having reviewed the motion, having reviewed the court file, having considered the arguments offered for counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. The court provided an ore tennis ruling. That's oral ruling, which we just heard. Ore tennis, that's a Latin way of saying we gave it orally. We gave oral. The court provided an ore tennis ruling on October 3rd, 2024 regarding defendant appearing in civilian clothing for trial and defendant's access to cosmetics and hairstyling throughout the trial. The court reserved ruling on defendants appearing before the jury free from physical restraints. In deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk that the security measures may impair the defendant's presumption of innocence. Absolutely agree with that. A court may order physical restraints only if it is found to be necessary to maintain the security of the courtroom. Before ordering a defendant shackled at trial, the trial court must make a case-specific and individualized assessment that considers 1, the defendant's criminal history and the nature of the pending charges, with special attention to whether either involved violent acts, or 2, let's see if we can embiggen this a little bit more for you guys. Let's see if we stretch this, it should be, there we go. There, now you can read it a little bit better from home. 2, whether the defendant has disrupted criminal proceedings in the past. Bump this a little, bump it to the left a little bit. There we go. So you can see the lettering. There we go. And 3, whether the defendant has engaged in any threatening behavior. There was no evidence that defendant has any criminal history. Defendant is charged by way of an information filed 3/23/2020 with a single count of second-degree murder. There was no evidence that defendant has disrupted criminal proceedings in the past or been a contumacious defendant. This is one of those words we looked this up during the Maya Kowalski trial. Contumacious, I believe it means like contentious and problematic and very, very Darrell Brooks like. We looked up contumacious once. It's like this is the second time in my life I've seen the word contumacious. Yes, a defendant's behavior stubbornly or willfully disobedient to authority. That's right. That was what the it's weird that there's a special, this is like a German, like how Germans have like words for everything. This is contumacious. A defendant stubbornly or willfully disobedient to authority. Wow. All right. So yeah, she has not been contumacious during court proceedings. There was no evidence that defendant has engaged in threatening behavior. So, based on that, orders and adjudges as follows. The motion is hereby granted. Defendant's shackles and handcuffs will be removed during trial proceedings. Done and ordered in chambers at Orlando, Orange County, Florida, this 3rd day of October, 2024. And there is no mention of a shock bracelet being worn. So, there you go. Win one. Yes, MG Law, we are now reading the court's rulings on the motions that we heard just now. So that's it. She gets to be free of restraints whatsoever. No shock bracelet, no shackles, no handcuffs. So win for the defense right there. Excuse me while I cough. I'm back. All right. I by and large agree with the decision. She isn't really a particular threat. I'm take it or leave it on the shock collar. I just think like shock bracelets are funny, but that's probably not the best grounds for making a legal decision. All right, here's the big one. This is a 10-pager, so buckle up, get yourself some breakfast, lunch, or dinner, or a drink, wherever you are. This is the order on the defendant's motion to suppress defendant statements at OXO. That's the Orange County Sheriff's Office. On defendant's amended motion to suppress defendant statements at the Sheriff's Department. And so on, defendant's second motion, blah, blah, blah. This cause came before the court on October 2nd. And we got all this stuff here. We can skip through all the magic words. The court, having received the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follows. All right, here we go. Here's the judge's ruling. And let's see. I want to see how much I can embiggen this and still have it readable. Is that going to work? Is that going to work? All right, let me just stretch this a little bit on my end, and that should give us enough wiggle room that we can keep it enlarged to this size. Let's move this somewhere else. I wish I could close that stupid thing. All right, we'll leave it down there. A defendant, Sarah Boone. Oh, wait, sorry. I want to get the super chat not out of the way. You know what I mean? Read it so it's not delayed for 10 pages. Jonathan Irwin drops the $5. I'm surprised Sarah and Lynette Preston aren't best of friends. Well, they're both in Florida. So who knows? They might know each other. I don't know. Defendant Sarah Boone is charged by way of an information filed 3/23/20 with a single count of second-degree murder. All right. On February 24, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. And yes, I know it says Jorge, it's pronounced Jorge, but everyone else pronounces it George, so we're going with George. And wait, I think I'm going to sneeze. No, I'm not. Okay. All right. Now, these are findings of fact by the judge. Deputy Kayla Rodriguez arrived on February 24, 2020, and spoke to defendant. She also states Exhibit 1. Detective Kopsel, a homicide detective with the Orange County Sheriff's Office, OXO, with 6 years experience and a homicide detective and law enforcement officer since 2013, was the lead investigator of George Torres' death on February 24, 2020. Detective Kopsel arrived at the scene within 30 minutes to 1 hour of the sheriff's deputies arriving, was briefed and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. And so why did he go through the house before the search warrant was issued? Because Sarah Boone gave them express permission to do so. Detective Kopsel was then made contact with defendant outside of apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Wow, this is like CSI Miami, actually. It's not Miami. It's like CSI Orange County. Defendant's cell phone was collected after CSI documented the scene. Detective Kopsel wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24, 2020 interviews addressed below. See also Defendant's Exhibit 1. Defense Exhibit 1 is the waiver. Detective Kopsel did not look at the defendant's cell phone, including any videos prior to the interviews addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Kopsel then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detective Kopsel and Lowen had an interview with the defendant in Detective Kopsel's unmarked Nissan Pathfinder at approximately 5 p.m. Detective Kopsel explained that she wanted to have conversation with the defendant after walking the apartment. Detective Kopsel testified that she would not have interviewed defendant outside the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective Kopsel in any recording. Detective Kopsel explained for purposes of this interview, including defendant's prior conversation with Deputy Kayla Rodriguez and Detective Kopsel's desire, we're going to call her Detective K from now on. Detective K desired to get a further understanding of what happened last night and asked defendant more detailed questions. Thereafter, Detective K began reading Miranda as follows. Detective K. Okay, here, this is actually what was said. Detective K. The 8 questions on Detective K's Miranda card were read as Detective K's Miranda card did not have question number 9. That's the footnote. I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? Defendant, yes. Detective K, anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective K, do you understand what I just read to you? Defendant, yes. Thereafter, Detective K interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. 2. During the second separate recording, defendant used higher tier words, including compos mentis. Yes, she loved that phrase, compos mentis, non-compos mentis, mentally incompetent. All right, where'd we go here? Where's our footnote? Aha. Detective K confirmed with defendant that no additional communications occurred prior to the second separate recording, and Detective K inquired of defendant prior to asking any other questions, you do understand that you don't have to speak with me if you don't want to, correct? The defendant responded yes. Pretty straightforward. Sounds like you read all the rights and asked all the right questions. After concluding the interviews, but before leaving, Detective K had conversations with defendant. Detective K had conversations with defendant had about coming to sheriff's office the next day to address the pending autopsy, and the Detective K would have more questions. Detective K did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective K would not have given a specific time frame for returning defendant's cell phone. Detective K had no memory of receiving a call from defendant on the evening of February 24th, 2020. Defendant's testimony largely agreed with Detective K's testimony, including the timeline of calling 911, speaking with Detective Kayla Rodriguez, and speaking with Detective K. As to the February 24, 2020 interviews, defendant confirmed that Detective K explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. Yes. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Detective Kayla Rodriguez. Yup, he's called BS on that. Yeah, she said she was under the influence of alcohol 15 hours after anywhere from 13 to 15 hours after she stopped drinking her half bottle of wine. Didn't see it, don't believe it. Defendant's statement of making a call to Detective K between 9:30 p.m. and 10 p.m. on February 24, 2020 from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. A very judicious way of saying she lied about calling Detective K between 9:30 and 10 p.m. Defendant claimed that before they left the scene, Detective K or Lowen would return defendant's cell phone to the apartment. On February 25, 2024, defendant claims that defendant and Detective K had a discussion regarding the picking up of the defendant's cell phone. Specifically, that due to Detective K's pregnancy, defendant needed to come down to the sheriff's office to pick up the cell phone. Defendant's sole reason for traveling to the sheriff's office was to pick up the cell phone. Footnote 3. Approximately 1 hour and 27 minutes into the February 25, 2020 interview, defendant returns to her list of prepared questions and specifically asks, "Am I getting my phone back?" This prepared written question would not be asked if one was told to come pick up a cell phone. Uh-oh. The judge calls out another, what he believes to be a lie. If she was coming to this station for the sole purpose of picking up her phone, why would one of her questions be, "Do I get my phone back?" Oh, zing. I didn't even pick up on that inconsistency myself, but that court did. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. Fair enough. On February 25, 2020, after Detective K reviewed some of the extraction of defendant's cell phone by digital forensics and attended the autopsy, Detective K requested defendant to come to the sheriff's office. Detective K did not want to approach defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez. The state and the defense agree that on February 25, 2020, the interview was custodial. She was in custody. The pith, oh, I like that. The pith of wasn't that a pither? The pith of defendant's arguments is contained in this exchange during the beginning of the February 25, 2020 interview. Before we get there, I just want to make one special statement and say thank you very much to This Is Flaming Dwagon. Ted Bundy wasn't a threat either, and he escaped. Well, he escaped a number of times. He was he was a special case. But, Sarah. And see Sarah just muscling her way out of the courtroom. The pith of the defendant, thank you very much, by the way. This is Flaming Dragon. Appreciate the comments. Always do. The pith of defendant's argument is contained in this exchange during the beginning of the February 25, 2020 interview. Detective K, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Detective K, appreciate you coming in. All the best. Defendant, yes, ma'am. I want to ask about these when we have a moment, referring to her pre-prepared written questions. Detective K, sure. So obviously he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it. Just like we did yesterday. So the argument was the defense was saying that she said, we just have to do it was in reference to we just have to question you. But here it makes it clear that this we just have to do it is we just have to read you your rights. That's how I read that. The footnote says, the court notes that this statement is an accurate statement of the law. See Wright v. State. And here's a citation. This is something I have to do when given the Miranda warnings. This is an accurate statement of law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. Again, I'm in agreement with the judge there. That statement, we just have to do it, was not we just have to interview you, so you have to sit through it and you have to tell us everything we want to know. It was a statement we just have to do it, meaning we just have to review and read you your Miranda rights. Defendant, normal protocol. Detective K, just like we did yesterday, Remember I read you the rights? Defendant, yeah. Detective K, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? So far, so good to me. Sure, says the defendant. Detective K, all right, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Defendant, no. Detective K, and do you understand what I just read to you? Defendant, yes. All right, whether the Miranda warning is sufficient. That's a very important issue to bring up, isn't it? The Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. Rigterink, Ragnarok, Rigterink versus State. The self-incrimination clause of Article 1, Section 9 Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to help them. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is not talismanic incantation. This is why judges, especially Supreme Court judges, they're cool. They get to use cool language. Me, I was saying magic words. There's no magic words in the Supreme Court judgment that says you must say these magic words or it's illegal. But you know what is so much better than saying magic words? Talismanic incantation. I feel shamed. I feel lesser. I only went to magic words. The Florida and U.S. Supreme Court went to talismanic incantation. That's awesome. That's some wordsmithing right there. They stress that there is no magic words, or, as they put it so much better than me, they stress that there is not talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Damn, I like that. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Quoting Duckworth v. Egan, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. Clearly, she's a straight A student. She excels at everything she does, according to her own words, so she understood it. There's no witchcraft allowed. No talismanic incantations. I love that phrase. Damn it, I wish I would have thought of that. The Miranda warning provided by law enforcement to defendant at the beginning of the February 25, 2020 interview is sufficient under both federal law, and Florida law. There we go. That's it. It didn't suck because you didn't ask question number 9. It's not invalid. It made the right statements. It was perfectly valid. The Miranda warning given to defendant in the instant case is identical to the exemplary Miranda warnings identified in Owens, supra see above. As such, the Miranda warning given to the defendant in the instant case was sufficient. You lose, defense counsel. You lose, Mr. Owens. Apologies, but you lose. Now, although the Miranda warning itself was sufficient under the judge's exactly MG law, talismanic incantations, it's the exact same thing. Talismanic versus magic, same thing. Incantations, words, it's the same thing, but God, so much better. Talismanic incantations. So anyway, although the Miranda warning was correct and valid, it can still be set aside if the defendant's statements were coerced. Well, let's see whether they were coerced or not. Spoiler alert, probably not. To establish that a statement is involuntary, there must be a finding of coercive police conduct. Coercive police conduct. Was it there? Generally, to determine whether a confession is involuntary or coerced, a court must examine the totality of the circumstances surrounding it. Where the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. There were no misrepresentations of the law regarding any defense, no quid pro quo, you give or take, no, you tell us this, we do this for you, no directly or specifically made promises, no overt act or threat of force against defendant was proved or claimed. And look at this, every single sentence. Well, it's all one sentence. Every single clause of this sentence cites a specific case to back it up. That is some good judging right there. And whoever his law clerk is deserves to get some sort of raise. No overt act or threat of force against defendant was proved or claimed. No fear of material or physical harm. No hope of material reward. No indication that defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24, 2020 and February 25, 2020. No indication that defendant is mentally deficient, especially considering the verbiage she used, i.e. non-compos mentis. Don't be throwing around them fancy words if you want people to think you're dumb. No threats, delusions. Well, there might be some delusions. No threats, delusions, deceptions, or promises. And defendant was offered water and breaks. There were no false statements made by law enforcement in order to coerce defendant to go to the sheriff's office on February 25, 2020, based on the findings above. Under the totality of the circumstances, defendant statements on February 25, 2020 were not coerced. Another loss for the defense. Whether the defendant's statements on February 25, 2020 were voluntarily made. That kind of goes hand in hand with the coercion, doesn't it? A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona. It was Miranda. I couldn't remember if it was Arizona v. Miranda or Miranda v. Arizona. All right. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. Barger v. State. To constitute a voluntary waiver, the state must show that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2, the waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Well, let's see. Factors relevant to consider include 1, the manner in which the Miranda rights were administered, including any cajoling or trickery, the suspect's age, experience, background, and intelligence, the fact that the questioning took place at the station house, and the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. There was no delay in the administration of defendant's Miranda rights. The recorded February 25, 2020 interview reflects that the defendant understood and acknowledged that she understood her rights. See Exhibit 1, that's her written waiver. Regarding her cell phone, defendant acknowledged that she understood her rights. Evidence supported conclusion that defendant voluntarily waived right to remain silent and obtained counsel when officer read defendant his rights and asked defendant whether he understood each of the rights, to which the defendant responded affirmatively. That's the holding in this Sliney v. State case. Now we're already into double A's. Ooh, double D's are coming up soon. Rawr. The court reincorporates its findings in section U and V herein, which further show no cajoling or trickery. That's basically saying these U and V up here, we're just repeating them down here. Defendant was 42 years old at the time she made the statements and appears to be of normal intelligence. February 25, 2020 interview did take place at the sheriff's office and no written waiver was secured. Under the totality of the circumstances. Under the totality of circumstances, defendant's statements on February 25, 2020 were made with a voluntary, knowing, and intelligent waiver. And this waiver was the result of a free choice on the part of the defendant and was not the product of intimidation, coercion, or deception. And that the waiver was made with full awareness of the nature of the right being abandoned. Double D. Orders and judges as follows. Here we go. The motion, the amended motion, and the second amended motion are hereby denied. You lose, sir. Good day, says Willy Wonka to the defense lawyer. He did his best. He actively and desperately tried to get this evidence thrown out. It failed. He did his best with what he had. He was given like a third of a deck of cards and expected to pull off a royal flush. Didn't happen. Bless him for trying. No other lawyer in the state of Florida stepped forward and made this effort that he made. You got to do what you got to do, and he did the best he could. So done and ordered in chambers at Orlando, Orange County, Florida on this 3rd day of October, 2024. Michael S. Kranick, Circuit Judge. E-signed. Certificate of service. There we go. La, la, la. Anita Barrios, Judicial Assistant to Judge Michael S. Kranick, page 10 of 10. There you go, peeps. That is his ruling. The motion to suppress all the statements she gave has been denied. No surprise there. Saw it coming a mile away. The judge telegraphed it repeatedly during the hearing. We were been talking about it for days because it ain't going away. We're going to trial. And we've got all the evidence. All the evidence is coming in, people. All right. We have cleared all of the super chats and everything. I don't want no super chat left behind. Denied. Exactly. Okay, so now what we've got coming up Monday, they're going to bring the jury in. Apparently, they've got a motion in limine he's mentioned. There's a couple of other motions apparently that are going to be made. So is it the Orange County where Orange County choppers was shot? No, that was different Orange County. That was New York. This is Orange County, Florida. Also not Orange County, California. So they're going to come to the trial on Monday. The jury, they'll go through, they'll get their pool, I think he said, of 50 jurors. Then they will tell them to come back later in the week and to do the final jury selection. And then I guess maybe during the first day or two, they'll be arguing all of these motions. So we expect the jury selection to begin on Monday. It will to a certain extent. They'll narrow it down to their final pool. Then we'll go there. Retro trial. No, we're not going to do Ted Bundy. I've got a different one locked and loaded. I don't even think Ted Bundy's trials were filmed, all of them. I don't think they were, because they just didn't do that back then. Right. Again, we're gonna have to see what the court schedule is. Now, here's my deal. If they show anything in the morning session, we will follow it. And we'll see what if they don't, we will be doing a playthrough of part 3 of our Phoenix Wright Ace Attorney game, where you all can help me solve a murder. And it's fun. Part 1 and part 2 are awesome. You can go check them out if you want. But we're going to have to see what happens on Monday when Monday rolls around. Sorry, I can't be more specific than that because the judge wasn't. So let's see. Okay, everybody, that is it. We have reached the end of the show, 3 hours and 55 minutes into it. I'm going to look for a place to send you. We've got 700 and okay, we just dropped down to 643 concurrent viewers, 767 likes. Come on, people. I need 33 more likes to get to 800. That would be super cool if we got to 800 likes. I would be just tickled 8 shades of pink. I was tickled 6 shades of pink a little bit earlier. And hit the subscribe button if you haven't already done so, because that would be super cool as well. I'd love to have your subscription. Especially, I'd love to have you follow me for this trial as we cover it gavel to gavel in my own special way. And for the final, we have 985 votes and only 768 likes on the like poll. Literally 220 of you cheated and voted without hitting the like button. Strawberries out like a light. You can hear the snores. It was loud. All right. Our poll today was, how should Sarah Boone be restrained during the trial? Well, we've learned that she's not going to be restrained at all, but you people think, 8% of you think that only leg irons is sufficient. 9% of you think she should be restrained with cuffs and leg irons. 26% of you, more than 1 in 4 of you, think she should be restrained by a shock bracelet. And 58% of you say she should be restrained by being zipped in a suitcase. That would be horribly prejudicial and totally unacceptable, but that is also my answer. Just because. All right, folks, join me on Monday to figure out what the hell happens, because we don't know. I'm gonna see who is doing what right now and where we can send you. And then it's what is it? It's 2 a.m. here. It's October, so I'm gonna watch me a horror film before I go to bed. I have like horror film rituals. Every October, the first thing I do, October 1st, I always watch Hellraiser. I don't know why, but that's how I kick off my Halloween movie watching. With Hellraiser. Hey, we've got 659 likes. That is so cool. We're subscribers. That means we picked up a bunch. We picked up almost 20 subscribers today. That's super cool. And if we just get 40 more subscribers, that'll get us to 80,700. I think we can get 40 more subscribers, 41 more subscribers while I'm doing this. Do it, people. I know there's 40 of you that haven't subscribed, and I'm not above begging. Please subscribe. See, does that make you happy? I would love your subscription. That would be super cool. All right, we are going to redirect you to we got Mystery Science Theater, Mystery Science Theater, Mystery Science Theater. There's like 18 Mystery Science Theater channels we can send you to. Catnut Williams is doing day 963,000 of the YSL trial. That looks like where we're going to have to send you. Oh, the lawyer you know. We're going to send you to lawyer you know. Because he is also reading this order. Let's go see what he has to say. See what his insight is into the order we just read was. So let's go on over to the lawyer you know. Make sure you tell him that Legal Vices sent you, and let him know he's the subject of a Vices raid. Traeger's awesome. I like Traeg. See you guys. I will see you. I'll see you on Monday, I guess. Have a great time, guys. Thank you so much, mods, for doing your moddy best. Chat, you guys were super freaking generous. We got to day 28 of the emotional support potato pig dog cam streak. God, you guys, I'm seriously humbled by the support you guys show me. I love each and every one of you for the super chats, for the gifted memberships, for the purchase memberships, and just for being here. Yes, Peter Tragos. We're going to send you on over to Peter. We love the Tragmeister. Tell him hi. Chat, just thank you for being here. Thank you for talking to each other. Thank you for talking to me and keeping me entertained. On that note, we are out of here. See you on Monday for whatever Monday may bring. Bye now.